As baby boomers age, experts predict guardianships for elders will likely increase. In fact, just in the past 10 years, the number of adult guardianship cases filed here in Orange County has seen a dramatic rise. With advances in medicine, people are living longer, and guardianship can play a critical role in efforts to support our aging population. Welcome to the Vital Living Forum. I'm Larry Stallings. In today's episode, we'll discuss the many aspects of a legal guardianship, how one is established, types of guardianship, and what to expect from a legal guardian. Joining us for this first segment is the Honorable Judge Thomas Mihawk, who served in Orange County's 9th Judicial Circuit Court for more than 19 years. In 2014, he was the probate and guardianship judge in Orange County until his recent retirement in January 2015. Also joining us today is the Honorable Judge Jose Rodriguez, who has been with the Judicial Circuit Court since 1987, and he currently presides over guardianships and mental health. Thanks for being here today. Judge Rodriguez, what is a guardianship, and why is it sometimes so important for our elders?
Well, a guardianship basically protects the elders, and it usually is when someone is not able to make certain decisions. So it's the way that the legal system has to protect those that may be more vulnerable and may not have the capacity to make decisions, whether they be to drive, to make contracts, to marry. In fact, it's a way, again, to generally care for someone who may not have the decisional ability that they probably enjoyed in younger years. But although older folks like us can go ahead and obtain the services of a guardian, there are also a lot of other individuals who, as adults, may have developmental needs that, again, a guardian might assist them. So there are a number of reasons why a guardian, but all of them are for the protection of the individual.
Good. Judge Mihawk, tell us about the state statutes that govern guardianship, and I'm guessing they're different from state to state?
They are, Larry, because guardianships are creatures of statute. So the legislatures of the various states will construct the guardianship framework. So depending upon what state you're in, you need to look at those statutes and rules to determine what's going to govern a guardianship there. In the state of Florida, we have Chapter 744, which is the primary statute that deals with guardianships for elders. There's also Chapter 393. Judge Rodriguez touched on the developmental disabilities. Chapter 393 deals with guardian advocates, which are people who are guardians for individuals with developmental disabilities. And I should also point out that there are also court rules that govern guardianship proceedings in court. Those can be found in basically Chapter 5 of the Florida Rules of Court. Starting with, I think it's chapter or rule number 5.540 and those that follow. So if you're going to be involved in a guardianship in the state of Florida, you need to check basically Florida Statute 744 and then Chapter 5 of the Florida Rules of Court.
Well, what are the general powers and duties of a guardian?
Well, I think you could begin by thinking of a guardian like a guardian angel. They're supposed to be doing everything for the benefit of that ward. The powers that they will have depend upon where the court, being guided by a group of physicians and a layperson, will make a decision as to where that individual isn't able or capable of making decisions. For example, as I mentioned earlier, perhaps the individual doesn't have the mental ability to form contracts. And contracts can also include contracts to marry if the individual may not be wise enough to make the decisions on that very important right. A guardian may also wind up taking a look at and caring for the individual's food, in other words, making sure that there are sufficient funds for the individual to have clothing, to eat, again, just to be well. That's a general, what a guardian generally does. In a way, everything that a family member would do.
Well, focusing on elders, what powers can be taken away when a guardian is appointed?
Well, the power to marry, the power to enter into contracts, the power to drive, all of those things that, again, depending upon your declining mental abilities and physical abilities, would necessarily have to be supplemented by someone else.
Now, how does this come into play with a level of guardianship? I've heard the words general and plenary, limited and plenary.
Plenary and limited.
Yes.
Let me back up just a little bit. There are two basic phases of guardianship. There's a guardian of the person, and then there's a guardian of the property, okay? Now, interestingly enough, the same person can be both the guardian of the person and the guardian of the property. You can have different individuals, one for the person and one for the property. And sometimes, even though I don't advise it, you can have maybe two people, as co-guardians of the person, and you would hope they would agree. I wouldn't recommend that. Okay, within that,
It happens.
It happens. Within that context, you also have plenary guardianships and limited guardianships, and those are pretty much what the terms indicate. In a limited guardianship, only certain rights, certain delegable rights are taken from the ward and passed to the guardian. In a plenary guardianship, basically all of the delegable rights are taken from the ward and given to the guardian. So that's the general structure of the guardianship situation here in Florida.
Precisely.
Well, and I think you touched on this a little bit, but what are the guardianship for elders, and how would that differ from guardianship for, say, children?
Well, again, it all depends on what the individual's abilities are, the mental and physical abilities. And that's what the guardian would have to tailor their services to. We wind up, there are professional guardians that wind up being paid for their services, and we always look in terms of what services are provided in terms of the needs of the individual. It's a very needs-driven service.
Something that I want to throw into that mixture before I turn the division over to Judge Rodriguez.
And in good shape, he did.
Thank you. I had some really tragic situations involving guardianships of children. I had children who were orphaned because their parents were murdered. And we had to set up a guardianship for them. I think the grandfather came in to act as the guardian of those minor children. I had children who were orphaned because their parent or parents were killed in an automobile accident. But I think the takeaway from that is, even if you have an intact family, if a child under the age of 18 comes into an inheritance, more than $15,000, the law requires a guardian of the property be established, even though you have mom and dad there, to protect that child's inheritance or whatever sum of money they may have come into.
You know, from a historical perspective, if we remember Jackie Coogan, who in later days became Uncle Fester, Jackie Coogan, when he was very young, was a protege of Charlie Chaplin, the comic, the silent film comic. And he wound up making an incredible amount of money. By 19 teens and 20 standards, he made a couple of $1 million, but by our standards, it was in the 40s and the $60 million. He got not a penny of that because his mother and stepfather squandered it all. And as a result of that, California, where he was obviously doing the film and where he was domiciled, started with the laws that started what we know today as the guardianships for young people. Again, it's a matter of us, as a society, protecting those that are most vulnerable, the kids.
And that surprises some parents when they come in and they say, well, this is my child, I should be able to take care of this. And the law says, no, you
No
can't.
way.
You have to have
No
a
way,
guardian
Jose.
because your child's got more than $15,000 here, and we're going to have the court supervise that.
And we've learned from past excesses that we do need to take care of the kids.
Right. Well, in your experience, what are some of the more common situations where a senior has needed a guardian?
Well, there are some warning signs out there with regard to when a senior may need a guardian. Let me throw some out to you. One situation is if you see mom sending $10,000 to the TV preacher in Iowa, for example, or making gifts that make no sense. Or maybe mom doesn't understand what her medications are for. Maybe doesn't go shopping.
Key.
Maybe her hygiene is declining. Maybe maybe she doesn't eat. Maybe the house is a mess. Those types of things suggest that you may want to take a look at perhaps a guardianship because things are not going well and mom really can't take care of her activities of daily living.
Memory as well. When memory starts to go, obviously that's critical.
Or in the case of my own mom, we never set up a guardianship. We didn't have to. But her eyesight was declining to the point where she couldn't handle her financial affairs. She couldn't look at a bank statement, understand what was in a bank statement, couldn't write checks, that whole kind of thing. So when those things start happening, you need to be alert to take
Those are
some
red
steps
flags.
to remedy
Those are
that.
absolute red flags.
Yeah.
Well, over the years, what are some of the trends you've noticed with senior guardianship? And I'm guessing they're increasing.
Let me answer that
Take it
one
away,
this way. First of all, I'm the leading edge of the baby boom generation,
Me too,
okay?
yes.
And I'm not too far behind in that conga line.
You know, that generation born between 1946 and 1964, that's the baby boom bulge, okay? We're all getting older and we've got that bulge in the population. So the demographics suggest that we need more capacity to handle guardianships. A couple other things factor into that. Of course, we're living longer. Medical science has kept our bodies operating a little bit longer, even though our abilities of cognition decline with age. That's another factor we need to consider. Another thing is the dysfunctional family, where you have mom in need of a guardian, but nobody can agree. Nobody trusts anybody, so you can't use alternatives to guardianship because people are fighting. The siblings are fighting. The children are fighting. Everybody's fighting. And lastly, you have the situation where you have families who may be intact but are scattered. Mom may be living in Florida, dad may have passed away, and you've got daughter one living in Boston with 4 children. You've got daughter number 2 in Seattle who's working 60 hours at a job, and nobody can deal with that situation. So all of those factors, I think, combine to suggest that we're going to have more guardianships as we go forward.
Yeah.
Right. Judge Rodriguez, now who can serve as a guardian?
Anyone can. We have professional guardians who basically take courses and do that for a living, as well as any member of the family. Now, we also would like and do request and require that folks that become guardians, that they do take a course so that they know exactly, more or less, what's going on and what their responsibilities are. Right. But anyone that's qualified, so long as you don't have a felony criminal record, or so long as you don't have a bad credit history, with a good credit history and no felony records, those are basically the qualifications.
And of course, we prefer residents of Florida if
Absolutely.
you're going to set up a Florida guardianship. But there are some exceptions in the statute that would allow certain family members who may live outside the state of Florida to be guardians of a ward, the person who needs the guardianship, who lives in the state of Florida.
I have a case right now that, based on the circumstances of not only the guardian, but the ward, the guardian lives in Georgia, but the ward is local. And there are, although the ward is local, part of the time the ward may live in Puerto Rico with part of the family, the other part in New York. So it's a roving ward, but again, the guardian, by agreement of all the siblings, is Georgia-based.
Well, I understand there's even different types of guardianships. For instance, public versus private guardianships?
Pretty much. The public, basically, some of them are appointed when there is a case that, for example, the ward is unable to pay and deemed indigent. And private, basically, when you're dealing with a professional guardian that would be paid.
Do you have a little bit
What
more,
other
Judge
insight?
Mihawk,
On the public guardian?
public.
Yeah, just a little bit. The public guardian, as Judge Rodriguez indicated, steps in when the ward doesn't have any assets. And all the expenses of that guardianship are paid from public funds. And you've got the public guardian, I think Seniors First here is our public guardian, and they're represented by essentially state-paid counsel. A counsel of criminal conflict and regional counsel's office will represent the guardian. The other thing is, the way the statutes are constructed, the intent is to try to get the public guardian out of the case as soon as possible. So the public guardian has a requirement in the law to report to the state agency for guardianships and to the court what efforts they have made to try to find a family member or a friend who is qualified and willing to serve as a guardian. The other thing that I'm sure Judge Rodriguez does, and I did a little bit, is you try to persuade a professional guardian. Try to persuade a professional guardian.
Did you say beg?
Beg, yeah.
But
and
in a
his
very
or her
professional
lawyer
way.
to take it on a pro bono basis. So that's the difference,
Yeah.
really. But otherwise, they're handled the same way.
And then how does that differ from private?
It's basically handled the same way, except for the funding, and except for the, like I said, the statutory requirement to try to get the public guardian out of the case, and try to get a family member or a friend to step in.
It's a matter of saving public money, but not at the expense of the ward. So at least the best efforts have to be exercised to try to get someone from the family, if possible, to do that. Sometimes there's nobody from the family, or family members may not be appropriate. So again, there's just a lot of, it's kind of like Jell-O, you know. You have to be very careful where you move because you don't want to sink.
I believe you mentioned temporary guardianship a while ago. When is that granted?
ETG. Why don't you go ahead? You go ahead
You go
and take
first.
that one. The ETG.
Well, basically, a temporary guardian or an emergency temporary guardian is just for that. During the time that somebody may be noted, where we may notice that someone needs a guardian, a petition is filed, and then what we try to do is we try to find somebody who will go ahead, at least on a temporary basis, assist that individual until either another guardian is found or until that guardian can be persuaded to pro bono take the case. And again, it's pretty much the same circular logic, where you go and you have someone on an emergency basis. What you try to do is to try to find someone either from the family, or if not, someone privately, to accept the case on an ongoing basis. And it may very well be that temporarily is all you need this person, because there are folks that, while they may be incompetent at one point, they may regain competence. And at that point, then they no longer need a guardian. So again, it's very fact specific. Like I said, it moves.
This is so interesting, and we're going to cover some more in our next segment, but I'm learning things myself, so I'm appreciating this.
Yeah, these guardianships, the ETG comes up usually, in my experience, when a social service agency is called in, and they may find an adult, let's say, wandering the streets, doesn't know where he lives, doesn't know who his relatives are. They find out that he lives in an apartment. The social service agents go to the apartment's a mess. There are unopened medications, rotten food in the apartment. So they immediately will file a petition to determine incapacity and a petition for an emergency temporary guardian.
We will touch more on this. This is so interesting. We've been discussing legal guardianships for older adults with Judge Jose Rodriguez and Judge Thomas Mihawk, both highly experienced with these types of cases for Orange County's 9th Judicial Circuit Court. We'll be right back. Welcome back to our Vital Living Forum on guardianships for older adults. Joining us again for our second segment are Judge Thomas Mihawk and Judge Jose Rodriguez. And before we get to our topic, I want you to complete your thought from segment one, Judge Rodriguez.
Well, we were talking about how folks came into the system. What I was commenting on was the fact that guardians could also be appointed by the Department of Children and Families, the Division of Elder Affairs, going out, and if there is an adult that may be running the streets, as Judge Mihawk was talking about, and he or she is found walking around aimlessly, they go back to the house, they find out that the house is a mess, that the individuals are really not capable of taking take care of themselves, then what they will wind up doing is they will file a petition for the protection of a vulnerable adult. And what they will wind up doing is it will take that individual from their home or from wherever they are and place them in an ALF temporarily until they can find family members or place them in a protected environment. So there is a means by which somebody who is running the streets or somebody who is not protected, the Department of Children and Families can file under the Florida statutes a petition to require that individual to be in a protective environment.
Very good. Now we want to talk about the process of guardianship. Give us an idea of how it begins.
Well, it begins with the filing of a petition. And again, it depends on whether you can be a family member or somebody, say, for example, went into the hospital, and as a result of what's been discovered in the hospital, that individual is not able to take care of themselves. They may not be any family. And again, that may qualify as an ETG situation. Until such time as a guardian is found, they'll place a petition before the court requesting that a guardianship be established. Any other insight?
Well, the insight that I would like to mention is obviously before you can establish a guardianship, which in effect takes rights away from the ward and transfers those rights to a guardian, which is a substantial matter and a serious matter. There has to be a determination of incapacity.
Right.
So what's going to be filed, usually together with a petition for the appointment of a guardian, is a petition to determine incapacity. And then the petition to appoint a guardian is usually filed at about the same time with that. But unless there's a finding of incapacity, there's no guardianship.
Okay. And my response was basically assuming that there was already a finding of incapacity.
Gotcha.
But again, the petition is what starts the ball rolling.
Right.
Well, who can be a petitioner for guardianship? And in elder cases, is there a typical person that's the petitioner?
In my experience, if you have the routine elder guardianship, you're probably going to have either a sibling come in and petition to be appointed the guardian, or a child, or there may be a contest among a child or children and siblings about who is going to be the guardian. But typically it's a family member in the routine elder guardianship under Chapter 744.
And remember in the last segment, Judge Mihawk talked about the fact that you may not want to appoint two. This is where one must resist the urge unless there is a real reason for appointing two, maybe guardian of the person, guardian of the property. But this is where, again, it can be very, very, very contested.
Yes, I think people are surprised by that when we have litigation, sometimes covering a trial day or more, where the family members are litigating about who's going to be the guardian for mom.
Right.
And as a judge, I'm sitting there trying to figure out what the motivations are.
You know, scratch your head. It's like, are you kidding?
Exactly. And I think you touched on this a little bit too, but what kind of documentation has to be provided to the court?
Well, the most important thing, I think, that people should realize is we are going, and Judge Rodriguez mentioned this before, we're going to ask for a private guardian now, a family member. We're going to ask for fingerprints so we can run a criminal background check, because it was mentioned by Judge Rodriguez that if you have a felony conviction, you're pretty much disqualified from being a guardian. Secondly, we're going to ask for sufficient information so that we can run a credit check with regard to the guardian because it's a fiduciary situation if you're appointed to be a guardian of a person's property. We want to be sure that there's no incentive there to maybe not do the right thing on behalf of the ward. Yeah. The other thing is that the guardian may have to furnish a bond. Because if a guardian is placed in charge of a substantial sum of money that or property that the guardian may have, we want to be sure that the guardian is going to perform their fiduciary relationships. And we've had situations where those have gone off the rails and the guardians have done things that the guardian should not do. So in very many cases, we're going to request a bond, or we can ask that the property, the cash at least, be placed in a restricted account, so that money can't leave that account without a court order.
Exactly.
But those are the main things. The application for the appointment of a guardian, you're going to have to, of course, give your background information, the ward's background information. You're going to have to identify the next of kin, their names and their addresses. And you're also going to have to identify the nature and value of the property that belongs to the ward.
You got to keep your eye on the ball, completely, totally.
So those are the things I can remember. But and Judge Rodriguez mentioned guardianship school. Yep. There's an 8-hour course that guardians have to complete. I think it's within a year.
Yes, and it's $100 from what I heard that it costs to take that course. Well worth it.
Right.
Well worth it to protect. And some of those funds are, from what I understand, used to fund some of the public guardians.
Right. Okay, so now a petition's been filed. What happens next?
Well, you go before the court, and then what winds up happening is, in some circumstances, in most circumstances, what you'll wind up having is you'll have an examining committee, and the examining committee will go ahead, usually 2 doctors and a lay person. Why do we have a lay person? Well, there are a few things that lay people can give their opinion in court, and an opinion be valid. And they are intoxication, not what we're dealing with here, and competence. So we have a layperson to tell us whether the individual that is being looked at is competent, and we've got 2 doctors from that perspective to tell us under what circumstances this individual can and cannot exercise his or her capacity. So, and again, we get the response, and then from that point on, that assists us in making a decision as to whether or not the individual is capable or not.
And let me throw in another factor here. In order to protect the person whose capacity is being challenged, that person is entitled to be represented by counsel.
True.
Typically appointed counsel. So when we make a decision with regard to capacity or incapacity, whether we're going to do a plenary or a limited guardianship, we get the input from the examining committee and from the attorney representing the ward.
Okay. Well, that brings me to my next question. Are there costs involved then with the incapacity process, and who incurs them?
Okay, let me start, and I'm going to let Judge Rodriguez jump in. The answer is yes, absolutely yes. Let's start. There are filing fees. I think the current filing fee for a petition for incapacity is about $230, the same for a petition to be appointed a guardian. There are examining committee members that have to be paid. They're paid roughly $350 each.
With the lay member being paid a little bit less.
Little bit less, yeah. And then, of course, if you have a professional guardian involved, there are going to be professional guardians fees. Under the court rules, guardians under Chapter 744 have to be represented by an attorney, so there are going to be attorney's fees. We have the fee involved with the bond premium, if we're going to require a bond from the guardian. And we have the cost of the guardianship school. And if you have a solvent ward, most of those fees, almost all of those fees, are going to come out of the ward's property.
Yep.
So there are costs, and you know, obviously you can reduce those costs if a family member can step in and be the private guardian as opposed to a professional guardian. But those are things that need to be kept in mind, I think, if you're moving forward with this process.
That's why you want to go ahead and find a family member that will be able to stand up and do what needs to be done, because it just saves an immense amount of money, and it saves an immense amount of, well, activity in court.
Sounds like there's a lot to establishing a legal guardianship. So how long would this take? And does that vary from state to state and county to county?
Tom?
I think if everything goes smoothly, it can probably take as little as 30 days. But if you get into litigation where the family members are arguing with each other, it could take months. Yeah. But and I think it varies from circuit to circuit. It depends on our caseload. It depends on how many contested cases we have, how many cases do we have to try, how many cases can be agreed to with regard to who's going to be the guardian and so forth. You may have litigation with regard to the issue of capacity. The family members may be arguing that mom isn't really incapacitated or not as incapacitated as the examining committee says. So it really depends on the circumstances of each case and what our caseload is like. And as you alluded to earlier, I think we're going to see more and more guardianships established.
Right off the top of my head, I can tell you that I remember there are 2 cases that are pending that have taken more than 60 days. Wow. And that to me is just too long. Right. And unfortunately, I've had to have some very Dutch uncle talks with the lawyers and everyone involved, because it can't be. We can't just be hanging out, and having an emergency temporary guardian that is taking that long. Statutes don't allow us to do that.
You have to do what Lyndon Johnson used to say, come in and let's reason together.
Exactly, exactly.
Well, speaking of capacity, what factors are in your mind when you're deciding on capacity? And do you have some cases?
It's the ability to reason. I mean, it's the ability to reason. I love to have the wards in front of me to listen to them talk, because honestly, you can get a real depth of feeling for what that individual is able to do and not do, other than through a secondhand version. Not that I don't trust the guardians, I do, but again, there's nothing more important than hearing from the ward. At this point, we don't have a lot of the wards appearing often, but when we do get them, it's a tremendous insight. But again, it's all about reasoning. It's all about mental and physical abilities. it is a wide world of input that we need to take up.
And I like to hear from the family members.
Yep.
I like to have the family members come in and testify what they think about mom's capacity.
Right, right.
So,
Right. And how about elders with dementia? Those are special cases. How
it's a
is that
special
handled?
case, I think, insofar as the protection aspect, because you know those folks are going to be more difficult to deal with.
Yeah.
So you have to have a capable guardian, especially if it's a family member. You're going to be looking at the physical circumstances of where the ward is going to be living. Is it a two-story house where mom is going to be on the second floor and she has dementia? Is she subject to wandering? Is mom going to be left at home while everybody else is at work? Is there a pond behind the house? Can mom trip the lock and go out and wander over to the pond and perhaps drown? So you have that aspect with regard to guardianship of the person. Then obviously with dementia, you need basically a plenary guardian of the property, of mom's property.
Right.
Right. And there have been cases, and we have one now currently, where the individual is brilliant. But the problem is that you cannot keep this person locked up anywhere because the individual finds a way out. So you have to study the individual, what they are likely to do, and then again work on that individual to make sure that you make every possible opportunity to safeguard that individual.
Are there less restrictive options than guardianship, and how can people find out about those?
Well, the two that come to mind immediately would be the durable power of attorney, which of course needs to be constructed before the ward loses capacity. So if a person has put in place a durable power of attorney, of course the word durable means that it would survive the incapacity of the donor of the power of attorney. But that
Lasting.
would give the holder, the attorney in fact that holds the power of attorney, the ability to deal with especially the property of the ward after incapacity. And the other, of course, is the designation of a healthcare surrogate, somebody to make healthcare decisions on behalf of the ward. Those two things come to mind, and in some circumstances they're good, in some circumstances they may not be so good, because when you use those devices you don't have court supervision.
Right.
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 Well, then when would a guardianship be best?
Oh, whenever you've got, more than anything, whenever you've got funds that somebody outside of the relationship needs to watch like a hawk. And also whenever you've got an individual that may have multiple siblings or children that are all, jockeying for position as to who's going to control mom or dad. I think that's pretty much when we become the Solomons to split the baby if necessary. Not that we do that, but still, just basically from an outsider perspective, to try to bring some common sense.
Yeah, it's the dysfunctional family that
Yeah.
would make those particular devices probably useless. And the other thing to point out is if somebody holds a durable power of attorney and a guardianship is filed, it invalidates the durable power of attorney, because the supervision shifts then to the court.
Okay. Judge Rodriguez, I understand there's a new project coming to the Ninth Judicial Circuit to help families of the wards.
You're talking about the elder coordination?
Right.
What we're going to try to do is, we've got a number of things that we can do to try and get things resolved before trial. Mediation is one of them but this is something that is a program where we're going to be part of a pilot program, if that's what you meant.
Yes, the elder care and coordination.
Yep. And what we're going to try to do is we're going to appoint these elder care coordinators who are going to be trained, and what we're going to look for them to do is, in high conflict situations, to try to work with the families to diminish and to downgrade any animosity, so that when it comes to court, we'll have these healthcare professionals, again, working with the family to try to minimize
So it should
any
run,
acrimony.
should run smoother.
We're hoping. Right now, it's kind of like a drip, because we're looking at appointing 3 for a 2-year period of for a 2-year. Actually, there's 3 elder care coordinators, and we're going to have 6 cases as a part of a pilot to study them and to do all kinds of statistic analyses to see whether or not this is something worthwhile.
We're about out of time. Do you have some final thoughts on guardianship?
I think they're awesome. I think they are, if you've got the right professional guardian, if you've got the right mixture psychologically, if you've got, it's like having a guardian angel. So I think, thank goodness that the law allows for that.
My last comment is the important, I think, thing for the ward is family involvement. If there's a guardianship hearing and you're local and you're a sibling or you're a child, come to the hearing. Ask for the reports that have to be filed. We haven't talked about those, but guardians are required to file reports with the court. So if you're a family member, visit the ward, get the reports, and be involved.
Be active, ask questions.
Very good. This is so informative. Thank you both for being here today to share your knowledge on legal guardianships as it relates to elders. I'm sure our viewers appreciate your walking them through the legal process basics and the many considerations that come into play when you decide on a guardianship case. When we return, we'll talk with a public guardian and a private guardian about their work and what is required of them as legal guardians. Welcome back. On this edition of Vital Living Forum, we've been discussing guardianships for older adults. In our third and final segment, we will learn about the role of the legal guardian. Joining us is Jenny Shuff Dowd, a public guardian, and Kelly Pittman, who works as a private guardian. Jenny Shuff Dowd has been the Director of Guardianship at Seniors First for the past 18 years and works as a professional guardian over the Orange and Seminole County Public Guardian Program. She also teaches the Family Guardian class for Orange County. Kelly Pittman has been a professional guardian for 14 years. She is registered with the Florida State Public Guardianship Office and serves as a court-appointed guardian in various capacities. Her experience also includes 10 years as a legal assistant paralegal. Both are here to explain how a guardianship works once they are assigned or appointed as the guardian by the court. Thank you both for joining us. In general terms, what is a guardian, and I guess what is not?
During the incapacity hearing, certain rights are taken away from the ward or potential ward at that time, and that is laid on the guardian. So whatever rights were taken away, it is up to the guardian at that time to pick up and take over those aspects of their lives.
Well, since you're talking, Jenny, as a public guardian, then tell us about your work with Seniors First.
Actually, it's the same as what Kelly and the professional private guardians do. I'm a professional. I go through all the hoops they do to get there. I take the 40-hour class and such. But actually, it's right by the statute. Everything's mandated by the guardianship statute. I have to abide by it the same. But I have oversight of the Florida, under the Florida Department of Elder Affairs, the statewide public guardian office also oversees everything that I do. So it's a little bit more detailed, a little bit more oversight. You got the statutes and then the oversight of the government office up in Tallahassee. But we either oversee the person or person and property, depending on what case we're appointed to.
Yeah. So how do you receive your cases, and are attorneys involved?
Most of our cases are quite dire cases. They either come like from the Sheriff's Department, DCF. A lot of them come from nursing home where they realize that maybe seniors were actually dumped there with no, not having anybody interested in their care. Maybe they're already seeing signs of incapacity, and that's when they go ahead and notify us to come in.
Right. And as a private guardian, do you receive your cases pretty much the same way?
I get referrals from attorneys. Some facilities will call me. I've gotten cases from Senior First. I've also received cases from the court. Not too many, but that's my referral source. Word of mouth is.
Yeah.
Well, I think we've kind of touched on this, but how does a private guardianship differ from a public?
It's about the same thing. We're still appointed by the courts. We still go through the same process of getting our cases. There's
Right.
still the same hearings. It's just The Seniors First are the ones that are appointed.
Well, and us as the public office, our folks have to have the adjudication of incapacity for us to have our funding and to keep the office as the public guardian office. Most of our cases are full plenary cases also, very little limited at, as a lot of the professionals see. So most rights are actually taken away from the ward at that time and given to us as the public guardian office. But basically it's the same. We operate the same. Me as the public office, I do have staff on board. I've got case managers, social workers, I have office help, and then me as the professional. And like Kelly as a private professional, it tends to be just her,
Right.
There is a few
One-on-one.
of them that operate a little bit differently, but mostly it's her, that's doing everything.
We hire staff. We can
Yes.
hire help, caregivers,
Right.
care managers, geriatric care managers. We can
Right.
hire out help, CPAs to do the taxes, stuff like that. But it's mainly just me.
Right.
It's
Because
my
her-
name on the letters of guardianship.
Right. Because her cases, they tend to have a little bit of money, and ours are strictly indigent. To be part of the statewide office, we oversee strictly the indigent, Medicaid eligible. Of course, incapacity, has to be done prior. So it's a little bit different, but not so much.
Right.
What are some of the trends you've noticed during the years for guardianship?
Well, I've seen quite a bit of changes in 18 years. I'm now teaching the class. I've been teaching about 10 years now for the family guardians. And I'm seeing a lot more of us baby boomers. I noticed the judges have talked about being part of the baby boomers. I am too. But more and more of us have already got our advanced directives in place. We've let our kids know what, we expect, who we want to take care of us. We have all legal papers signed, maybe filed away, our wills done and all. So I'm seeing a lot more of that where the families are already prepared instead of having, all of a sudden, wow, this person, this loved one needs a guardian, and all of a sudden you're looking at attorney fees, filing fees and such. So I'm seeing a little bit more of this education coming out and families prepared.
Now, there are different levels of guardianship. I remember the terms plenary and limited.
There's there's three actually, because you can also have a volunteer guardianship where somebody's competent, but they just need that little help to oversee some things.
The
But
finances.
mainly the finances.
Yes.
You have to have a letter from the doctor saying that they're competent. They're still overseen by the court, but they can be discharged at any time because the person is competent. But the plenary is pretty much everything. All their rights have been taken away and given to me or another professional guardian. The limited ones are just specific rights are taken away, and those are the only ones that you deal with, not the ones that they retain.
Okay. Well, as a private guardian, what specific kind of things do you offer for?
Well, it depends on what rights are taken away from them, but it's, usually, generally speaking, it's medical rights, making medical appointments, consenting to medical treatment, finding placement for them, paying their bills, applying for benefits, either Medicaid or some VA benefits that might be out there available for them.
Okay, and as a public, is it pretty much the
Actually,
same?
exactly the same, exactly, yes.
Now, how are these requirements the same or different for a private guardian? Well, I guess that's what.
Well, I'm a private, but I'm the Orange County Public Guardian, and also Seminole County.
I see. Gotcha.
We abide by the Florida statute, guardianship 744,
Right,
and it's exactly as Kelly, does. Everything's the same.
Well, then, how is public guardianship funded?
Actually, it is up to each of the offices to find their own funding. We do receive funds from Tallahassee under the statewide public guardian office for both counties. And we actually have contracted with the city of Orlando. I receive a little funding from them, and also Orange County, the court system. And with that funding, that determines how many cases the public guardian office can take at that time. Right. And we just moved into Seminole County, and so we're opening up a few slots there underneath that funding.
So I guess then private funding is different.
Private funding is different. We only get paid when the courts say we get paid is the biggest thing, but the person has to have money to pay us. The courts don't pay us, the county doesn't pay us, the state doesn't pay us, the person has to have money. And then when they run out of money, you still are involved. You generally can't just give up something like that, but you try to get them on Medicaid so at least their bills are paid. But generally, that's how we get paid, is from them.
Under the public side, for somebody to actually come in as a ward under the public side, I determine at the time before, going to court for them that they are indigent, strictly indigent, Medicaid eligible, they have no other resources. I look for hidden resources and all, because those are the cases that Kelly and these professionals, would be better at tasking to do. And also the state does not allow, under their funding, for me to take those cases.
Well, now, how are all these charges tracked? Does the court do that?
Well, I have a billing system, and I have to apply to get paid. And the courts tell me. I also am responsible to do accountings to the court, so it shows exactly how much I spend and how much I'm spending on everybody's money, what their cost is, what medical is, everything like that, and what money's coming in. And the courts oversee that, and they audit each one of those.
So a family member can request the statements from you to see how the charges are mounting up, how are going.
A family member can.
Right.
Usually it's through the court system, but they absolutely can. And it depends on the guardianship, because if it's a limited guardianship, then my accounting has to be mailed to that ward.
I see, gotcha. Now, speaking of family, how can family members keep involved during the guardianship?
Well, sometimes you don't want them involved, and other times you really stress involvement. That's as a good guardian, you want to know the players. And a lot of, when you're opening up the case, you have a lot of research, talking, reading, maybe reports, sheriff's reports. A lot of it's not real good reading, especially before night, if you want to sleep good.
Right.
But, you determine that way who should be privy. Of course, we're versed on, and as far as the HIPAA regulations, a lot of it has to do with medical information. You have to be careful there. And I think each guardian takes it, each case individual
Right.
to determine how to work with those family members. My case is not necessarily does not have family members. Under the state, they direct us to only become guardians, public guardians of those without family or interested parties, because you're talking about the resources of the state are tax dollars. So we're in place for those without family members, basically.
And the family members that I deal with, we have voicemail, we have texting, we have email, we have
Right.
all kinds of technology that helps. It's easy to run off of email to, several different family members just to let them know, Mom had this doctor's appointment, everything's fine, and then move on.
Right. The judges talked about credentials. Well, what kind of credentials do you have to have then for?
Well, we both, I believe, have the same thing.
think so,
We
yeah.
had to take the 40-hour guardianship class, pass the state test every year, or actually it's every other year I get my credits. You have credit, what is it, 18?
It's 16.
Is it 16?
Yeah.
Okay, 16. So every 2 years we do that. We attend, a lot of my credits I get from the Guardianship Convention. They're all online. A lot of them are online. I'll go online and keep up with my
Right.
classes that way too.
Back to families. What happens if they run out of money?
If the ward runs out of money,
Yeah.
in my situation, I'm hoping that they'll get on Medicaid. I'm hoping I've done my job right and I've got them on Medicaid or some other maybe benefits through the VA, if that's possible. But I no longer get paid. But the state will, they'll still get paid. Hopefully they could stay where they are. It depends on the facility they're at versus an assisted living versus a nursing home.
Right. Are there situations where a family member is appointed as a guardian rather than a public or private?
Oh, yeah. Yeah, in fact, you'd mentioned at the earlier in the show that I teach the family guardianship class. I've been doing it for 10 years now. Actually, Judge Perry had signed an order for Seniors First to teach. And what this is, I'm seeing more also that these family guardians are having to take the class before actually the hearing. So they kind of know what they're getting into. So these are family members that's doing it from, the goodness of their heart, loving their family. They're not getting paid for it. So, but the courts at the same time wanted to know that the standards is what, and the hoops that we jump through, they're expected, but as a family member.
Right.
So, yeah, we have seen big growth here in Orange County with family guardians.
And sometimes once they take the class, they don't want to do it anymore.
That's right.
Right.
That's
So
right.
it just all depends on what's going on.
Right, right. So, Jenny, with all of your experience in the field, what's your best advice to viewers who are looking at guardianship?
My best advice is to talk to your parents before they get elderly. Try to get things taken care of for yourself and them. Look in safe deposit boxes. Look in the bank, whatever they have stowed away. Talk of their wishes. What do they want to see? Where do they want to be placed, if placed at all, and with whom? You know, who do they want to take care of them? Right. That's the best advice, is to know your loved ones and be prepared to step into that role.
Yeah. Final thoughts?
You know, guardianship is expensive. Sometimes it's necessary, sometimes it's not. You should try to get your affairs in order with a power of attorney, a living will, because that could avoid some guardianship cases.
Right.
This should be looked at as the last resort.
Right.
And I think that's a good way to close it up. It's the last resort.
Exactly. Very good. Thank you, Kelly and Jenny, for all of your expertise. It was so informational.
Thank you for having us.
They shared their expertise on guardianships for older adults. And from what all of our guests have shared here today, a legal guardianship might be the solution for some elders in need of a primary caretaker. But it isn't the only one. When considering this option, it's important to gather your facts so you can make an informed decision on whether guardianship is the best choice for a loved one. The Vital Living Forum is part of Orange County's Vital Living block on Vision TV. For more information, please visit us on the web at orangetvfl.net or contact the Orange County Office on Aging at 407-836-6563. I'm Larry Stallings. Thank you for joining us.